In this video I want to take a look at a January of 2020 decision to do with a judgment mortgage being registered on a property that was held jointly by a father and son. So Mr. Berrigan Senior and Mr. Berrigan Junior in Kilkenny have a piece of land, and the son gets into difficulty. There's a judgment mortgage registered against him, and it's slapped on the property in 2010. The father then, he's a joint tenant, remember, with his father. The father shouldn't really, according to himself anyway, because he didn't get into any difficulty in terms of the borrowing, felt that he was entitled to deal with his interest in the property whatever way he chose, and he was concerned that this judgment mortgage would end up seeing his interest in the land going to the lender, when in fact he obviously wanted to give it to his grandchildren. So the judgment mortgage was registered in 2010. In 2013, Mr. Berrigan Senior created a tenancy in common situation. In other words, they split up or severed the joint tenancy and created tenants in common interests. So each of them then held 50% of the property as a tenant in common. So the grandfather then, or Mr. Berrigan Senior, made a will and he passed away, and he left his interest, his 50% interest as a tenant in common, to his grandchildren. He did that in 2013, remember, 3 years after the judgment mortgage had been slapped on the property. The lender came along then and said, he can't do that, we have a judgment mortgage on the entire property, and they went to the High Court to have it enforced. The High Court held that Mr. Berrigan Senior was entitled to deal with the land any way he wanted to, because the judgment mortgage did not affect his interest in the land, it only affected the son's interest in the land. And the High Court held that the father was entitled, or Mr. Berrigan Senior was entitled, to create a joint tenant in common situation as opposed to a joint tenancy, and was entitled then to do with his interest in the land what he wanted to do with it, and he wanted to leave it to his grandchildren. So that was fine. The High Court, as I say, said that the judgment mortgage did not attempt or did not affect the Mr. Berrigan Senior's interest in the land. It only attached to the son's interest, and that was the tenant in common interest. And he also held that the judgment did not, as I say, affect the father's interest in the land, who was a joint tenant at the time of the registration. It only affected the son, the borrower's interest, and the judgment mortgage did not attach to the land in Kilkenny, but only to the son's interest in those lands. And the judgment mortgage did not sever the joint tenancy. However, the joint tenancy was severed later on, 3 years later, when Mr. Berrigan Senior decided with his son to create tenants in common interest in the property rather than joint tenancy. It's an interesting case. Obviously the lender was frustrated, etc., but Mr. Berrigan Senior didn't owe any money, and his interest in the land was not affected according to the High Court. The decision was handed down in January of 2020. It's worth having a look at. I've written a blog post about it on my website, businessandlegal.ie, and I have published actually a link to the full decision. So if that sort of thing, joint tenants, tenants in common, debt and so on and so forth, judgment mortgages, affects you, you might be interested in reading that article and having a look at the decision and having a look at the thinking of the High Court in the case. It's on my website, businessandlegal.ie. I hope you find this video useful. If you do, I would appreciate if you gave it the thumbs up down below, and you may be interested in subscribing to my YouTube channel. If you are, hit the subscribe button and ring the bell thing, or click on the bell icon, and you'll be notified when I make a new video or publish a new video.